At Raju Law, we don't just provide legal services, we provide a pathway to your American dream. With offices in New York, Los Angeles, Washington, D.C., Atlanta, Dhaka, and Dubai, our global team is dedicated to delivering personalized immigration solutions. Whether you are pursuing a green card or navigating complex immigration processes, we are here to guide you at every stage. With a team of 10 associate attorneys and more than 180 law clerks and case managers, we craft solutions tailored to your unique needs. Our technology-driven platform ensures the fastest, most efficient service, saving your time while upholding the highest standards of quality. At Raju Law, we believe in affordable, transparent pricing without compromising on service excellence. Raju Law, where your American dream meets expert legal support. Contact us today.
Hello and welcome everyone. I'm Manshi Katira and I'm absolutely delighted to have you with us for another episode of Immigration for All, brought to you by Narohi Global and proudly powered by Kulna Tech. If you have been tuning in, you know that we recently rebranded our Monday Live series to Immigration for All, a name that truly reflects our mission to make immigration knowledgeable, clear, accessible, and practical for everyone, no matter where you are in your journey. And here is some exciting news. Our show is now officially available on Spotify and Apple Podcast. Whether you are commuting, working out, or just unwinding at home, you can watch our episodes anytime, anywhere. Today, we are diving into a fascinating and empowering topic: self petition for O-1 visa. If you are someone with extraordinary ability in your field, be it in arts, science, education, business, or athlete, you might be eligible to petition for US visa on your own without needing a traditional employer sponsor. We will be breaking down what it means to self petition, who qualifies, how to build a strong case, and common mistakes to avoid. This can be powerful option for highly accomplished professionals and creatives, and we are here to unpack it all. Now, without any further delay, let's welcome our special guest, Mr. Raju Mahajan, Principal Attorney at Raju Law. Mr. Mahajan.
Thank you very much, Manashi, for inviting me here. And thank you all of our audiences and viewers who are watching at this moment live or who will watch later in our different platforms later. So as Manashi said, our topic today is, by the way, Manashi, how are you?
I'm good. How are you, sir?
I'm good, good. Thank you. Sorry, I forgot to ask you. Okay, so I'm going directly to the topic to save in our audience's time. So our topic today is O-1. So I'm going to talk about O-1 visa, especially self-sponsored O-1. So I would like to see the PowerPoint. Let me present. Yeah, okay. So, all right. So, dear audience, our topic today is self-sponsored O-1 visa. So, before I talk about O-1, let's make some clarifications. So there are some confusion about self-sponsorship. So let me clarify that one. So there are some applications like NIW, EB1, and there are some other applications like that. These are the application you can apply by yourself. You do not need any job here in America. Your company, your employer do not need to sponsor you. It's a self-sponsored application by itself. Anybody from anywhere in the world, if you qualify for NIW or EB1A, you can directly apply by yourself. Of course, you can take help from an attorney or expert person. That's a different thing, but you do not need an employer to apply for that. And these are also green card applications. On the other hand, there are some applications that requires an employer. You cannot apply by yourself. It's called employer sponsored application, like H1B, O1, regular EB2, EB3, EB4. Those are the things that you need a sponsor, and your employer who is sponsoring you, they are going to apply for you. You cannot apply by yourself. However, H1B and O1s, and there are similar other applications. Technically, you can apply by yourself. The way you can do it, that's the topic of our discussion today. Even though it is mandatory to have a sponsor, you cannot apply by yourself, but basically you can apply by yourself. That's the topic for our discussion today. So please pay attention. You will learn a lot of new things today. And just for our discussion today, we are going to talk about O1, but sometime later, like another day, we will also talk about self-sponsored H1B visa too, but not today. Today, we are going to focus on O1 visa. So the question is, what is a O1 visa? O1 visa is for individuals, like the way Manushi said, O1 visa is for individuals who demonstrate extraordinary ability in the science, arts, education, business, or athletics. So the key term is extraordinary ability. You must be a person of extraordinary ability. You cannot be just a random guy, like, hey, I'm going to apply for O1. That's not going to happen. You must establish that you are a person of extraordinary ability to apply for O1 visa. Also, this year, January 8, 2025, US Policy Manual update explicitly permitted beneficiary O1 visa However, in this year's January 1 USCIS policy manual, they make it very explicit and they make it very easy for self-sponsored O1 visa. And that is our topic today to discuss so that you can take advantage of this great benefit. Now, you may ask me a question, hey, you just said to apply for O1, there must be an employer and the employer must apply for me. Then how could I apply for a self-sponsored O1 visa? So that's the tricky part for our discussion today. So basically the way it works is you own a corporation, you own a business here in America, and your business is going to sponsor you. So that's that. So it meets both both of the requirement, right? So yes, it is a employer-sponsored application. Your employer is going to sponsor you, yes, but you own the business. So you are the employer, and also you are the employee. So you as an employer is sponsoring you as a beneficiary. So it's a self-sponsored application. But things are not that easy, right? Nothing in America is that easy. You say we are talking about American visa. Of course, it requires a lot of lot of documentation, a lot of information, a lot of evidence. So how a corporation owned by you is going to sponsor you, that is our topic today. Number one, so what are the requirements? So there are two major kinds of requirement. One is business requirement. One is you as a person, as a beneficiary requirement, right? So first we are going to talk about business requirement. Very first, you have to form a business. And in general, there are two major kinds of business. One is called C Corp, one is called LLC. I'm not going that detail into LLC versus C Corp discussion today because that's a business legal matter. Probably we'll talk about that some other day. But just for clarification, you can either register C Corp or a LLC. Both of these will work. But in general, anytime anybody apply for any immigration benefit, no matter it's a O1, H1B, or any kind of visa, most of the people, I'll say 98% or 99% people, they form LLC because it's easy to form a LLC. It's easy to run. It's easy for many different reasons. So let's say LLC, but just for the discussion, it can be C Corp too. Once you register your business, it must be a bona fide business. Meaning, in a lot of time, people say, "Oh, okay, I'm going to register a business, register a LLC, and then I'm going to start me." That's not going to happen. It must be a bona fide business. The purpose of if the purpose of the business is to sell coffee, you must actually sell coffee. It must be a real business. It cannot be like a just paper business, like business in paper. In reality, it doesn't exist. And if you apply for yourself, most likely your application will not be approved, right? So it must be a bona fide business, proving the bona fide employer-employee relationship. Also, so the tricky part is, you are the employer, you are the employee, you are the same person doing everything. But in paper, all the things must establish it's a bona fide employer-employee relationship. Like you as an employer, you're going to send the employment contract. You as an employee, you are signing it. what would be the salary, what would be your job responsibilities, what would be your day-to-day work look like. Everything must be clear. You should be prepared as if it's a real business. And when you act like an employer, you should act like a real employer, like a real employer, not just a, oh, I'm going to make everything easy for me because I'm also being the employee. On the other hand, when you act like an employee, it must be like a real employee kind of attitude. So you act like a real employee. So there must be a bona fide employer-employee relationship. Again, I'm not going that detail into every topic here because that will make this video like a 2 hours long. People will be bored. So I'm just going to just give like a big picture idea. Number three, establishing legitimate business operation and financial capacity. As I said, if it's a coffee shop, you must sell coffee to real people, like real people, and there must be some sort of financial capacity. So let me give you an idea. So let's say IT company. I'm just giving an example. Let's say you started a software company here in America. You as a employee, as a software engineer, you are building the software and your company is going to sell the software to clients. So there must be real legitimate clients, right? Who are going to buy your software or who are going to take service from your software company. Also, you must make enough money so that you can sponsor yourself. So let's say your annual salary is 60,000 US dollar to sponsor yourself. So you must make more than 60,000 US dollar to sponsor yourself. If you make 40,000 US dollar per year in your business, and if you're going to sponsor you and your salary is $60,000, USCS is going to ask you, hey, you make 40,000, you have to pay $60,000 salary. Where this $20,000 will come from, right? You have to be prepared to answer this question. So there must be a legitimate business operation and financial capacity. Number four, securing adversary opinions and expert letters. A lot of time, this is not mandatory, but this is like a highly recommended, because since you are the employer, you are the employee, I highly encourage you to get some advisory opinion from some labor organizations or some trade organizations, who are the governing authority in your industry. And if there is no governing authority, like if you ask me what is the governing authority, so let's say me as an attorney, I am required to follow all the rules and regulations of bar association. Bar associations is my governing authority. I cannot do anything without permission from the bar association. So similarly, if you're a dentist, there is a American Dental Society or like a state dental society, you have to follow their rules and regulations. If you're a doctor, there's an authority. If you're an accountant, there's an authority. However, if there is no authority in your industry, then you have to take some expert letters, like letter of recommendation from the peer in your industry, and they will testify that this is a real business, it's a bona fide business, there's a bona fide customer, there's a financial capacity, and all the things they are going to testify, right? So these are the requirements from business entity. Now we are going to talk about the beneficiaries requirement. Like remember, in this scenario, you are the employer, you are the employee. So we just talked about the requirement for the employer. Now we are going to talk about the requirements for employee, you as a person. So the applicants must meet at least 3 of the 8 criteria. If you meet more than 3, that's great. Then your application will be stronger. In fact, I personally recommend all my clients to meet at least 1 more than 3, like at least 4 criteria, so that in case USCS say, no, you do not meet this criteria. If they, deny one of the criteria, at least you have 3. If you meet at least 3 criteria, then your application will be approved. So what are those 3 criteria out of 8? Number 1, nationally or internationally recognized awards or prizes. Now, in many industries, there's no award or prize, right? Like me as a lawyer, there is no nationally or internationally recognized award or prize. So how do I establish that? Most likely you cannot. But in some industry, there are some. So let's say you are a very good fashion designer, and you're going to start a business here in America as a fashion designer, fashion house, and there is a nationally or internationally recognized award or prize. You can definitely meet this criteria. Number 2, membership in association in the field which require outstanding achievements. This is the tricky part, outstanding achievement. This is not a regular group. This is not a regular membership. It's not a group that, I'll pay like a $200 per year as an annual fee and I'll be the member. It will not qualify. It must be a membership in an association in the field which require outstanding achievements of the members. So this is kind of like, very tricky part. Number three, published material about the beneficiary. Let's say there is a newspaper, there's a television, there's a radio, there's a very famous YouTube channel, there's a famous blog website. They published material about you. They said, oh, you are a great person, you are studying a great business, this benefit is going to, benefit America, blah, 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 all the good things about you. So it's a published material about you, not by you, by someone else about you. Number four, original scientific, scholarly, or business related contribution of major significance. This is a kind of catch all. Many people may qualify for this. So we have to establish that your contribution in your field is original and also it's a major significance. There's a two part. It must be an original contribution. Also, it must be a major significance. Number five, authorship of scholarly articles. This is kind of easy. Many people, especially those who are in, like a highly educated, like who have a master's degree or PhD degree, many of them, they have authorship of scholarly articles. So if you have authorship of articles, you can easily meet. By the way, let me talk about a little bit about some different things, which is very relevant here. A lot of time people ask me question, hey, what is the difference between H-1B and O-1? Well, for H-1B, there's a lottery. For O-1, there's no lottery, which is great. So there can be unlimited number of, but for H-1B, there's only limited number. Number two, for H-1B, there is no need to be extraordinary ability person. If you have a bachelor degree in any field where your employer is interested to hire you, they can apply for you H-1B. It's very easy. Millions and millions of people have H-1 bachelor degrees, so they all can qualify for H-1B. On the other hand, O-1 is for extraordinary ability person, not for everyone. So in general, I tell my clients, if you have a master's degree or higher degree, then you qualify for O-1. O-1 is not for everybody. And again, you have to meet 3 of the 8 criteria. So especially in the authorship of a scholarly article, in general, people who have like higher aptitude, who are like a very real good student, they usually have this. So if you have a scholarly article, then you may qualify for that. Number 6, a high salary or other remuneration in your industry. So it depends on the location, it depends on the country, it depends on the profession, but this is kind of easy to meet. The next one is participation on a panel or individual as a judge of the work of others. So this is kind of, if there is any big competition, as I said, if you're a fashion designer, if there's a national or international competition, then you can be judged. You can be invited either as a person or as a group, you can be judged. Also, if you are in academic field, if you review the journal of other people, if you review the scholarly article of other people, then you also qualify for this. And the last criteria is employment in a critical or essential capacity. So your employment must be a critical or essential capacity. So it's not like a just regular, it's not just, like manager, like a day-to-day manager. That will not be a essential or critical kind of job. I would say, like if you're a software engineer and if your software is very significant to the country and you are the essential person of this business, so then you may qualify for this. So these are the 8 criteria. You have to meet 3 of these 8. All right, so which is the form? The form to apply for O-1 is form I-129. So people are confused many times about form I-129. I-129 form is used for at least 10 or 15 different applications, and it's a huge form. It has multiple sections. Some section is for H-1B, some section is for O-1, some section is for other kind of application. So when you fill up the form I-129, some part is for everyone. Like it's kind of a more of a biography kind of person, your first name, last name, date of birth, your address, your employment, blah, blah, blah. And then when you go to particular section, you have to only fill up the section for O-1. Do not fill up the entire form. USCIS officer will be confused, like, what you're applying for. If you fill up the area for H-1B, people would be confused. So only fill up the area that is relevant for O-1 application. At this moment, also fees get changed pretty often, so it's very hard to talk about fees. But let me tell you, at this moment, the standard fee is for $1,055 for regular employers, $530 for small employers, 25 or fewer full-time equivalent employers, or non-profits. There is an additional asylum fee. I'm not going that detail why there's an additional asylum fee, but just to please remember that there's an additional asylum fee of $600 for general businesses, which is 25 full-time employee or more, or $300 for small businesses and $0 for non-profits. There is an additional premium process fee of $2,805, and you'll get result for 15 business days. Processing timeline, there's a standard processing of 7 to 10 months. Premium process will give you result within 15 days. So they're both good and bad about premium process. Again, I'm not going that detail into today. Our main focus is O-1 today. So that was my short presentation today. Going back to Manashi. Manashi.
Yes, hello. Thank you so much, Mr. Mahajan, for such a clean and empowering explanation. You've taken a topic that can seem exclusive or confusing and made it accessible for so many talented individuals who may not realize this path is open to them. Before we move to our Q&A session, let's take a very short break. So stay right here. We will be back in just over a minute.
Are you a leader in your field, an innovator, artist, scientist, or entrepreneur? You may qualify for the prestigious EB-1A Extraordinary Ability Visa, your fast track to a U.S. green card with no job offer required. At Raju Law's Dhaka office, we specialize in building powerful EB-1A petitions tailored to your achievements. With expert attorneys, global experience, and a tech-powered process, we bring U.S. immigration success to your doorstep. Your extraordinary talent deserves an extraordinary path. Let Rajula Dhaka open the door to your American dream. Book your consultation today.
Welcome back, everyone. It's time for our live Q&A sessions where we answer your most pressing questions. We received several excellent ones, from how to prove extraordinary ability to whether you need US-based press coverage to qualify. Mr. Mahajan, we are excited to hear your insights on these real-life scenarios. So let's start. First question is, in what situation can someone apply for an H4 EAD?
So there are multiple situations where a H4 dependent can apply for EAD card. So let me tell you what H4 is. So anytime anybody here in America under H1B visa, their dependents, meaning their spouse or children, they will be in H4 category. It's called a dependent visa. So especially spouse, they may qualify for EAD card, work authorization, if they meet any of the two criteria. Number one is if the H1B holders I-140 petition is approved. If there's approved I-140 petition, then a spouse get work authorization. Or if the main H1B applicant, if they pass 6 years of H1B and then go beyond 6 years and they still in H1B, there's a different law. It's called AC21. If they're in under AC21, then the spouse, excuse me, get EAD card. So if you meet you don't need to meet both. You just meet one of these two. If you meet one of these two criteria, then the dependent can apply for EAD card. And in general, it get approved. It's not a merit-based determination. It determines the two things I mentioned. So they get work permit.
Thank you so much. Second question: my H1B spouse lost his job. What will happen to my H1 4 status and H4 EAD?
So that's a very good question. And nowadays, because of this volatile market situation, a lot of H1B holders, they lose their job. Once they lose their job, so from the last day of the work, they have 60 days grace period to find another job and to move to a new job. If they cannot find any job within 60 days of losing their job, then their H1B would be void. And subsequently all H4s will also be void. So this is a very tricky situation. That's why to avoid this kind of situation, a lot of people who are in H1B, they get a second job under concurrent H1B. It's a totally different subject. I'm not talking that. If you go to a YouTube channel, there's a video about concurrent H1B. So a lot of people, they have a second job called concurrent H1B, or the way today we are discussing about self-sponsored O1. So a lot of people, they have their own LLC, they have their own business. up and running, generating revenue every day. So in case they lose their job under their H1B, they can immediately apply for a transfer to their own business from their, let's say they were employed by big corporation like ABC Corporation, and they have a small startup called PQR. So if they lose their job from ABC Corporation, they can transfer their job to their own business called PQR, and that can also save their H1B and also all the subsequent H4. So the short answer to your question, yes, if H1B lose their job and they go out of status from H1B, then all H4 will also lose their status.
Thank you so much. My H4 visa stamp in my passport is expired, but my 194 and H4 status are valid. Can I travel outside the USA? US?
Yes, you can travel. Yes. So the thing is, if your visa is expired, so there's two different thing, visa and status. So visa is not very important. Once you are in America, visa is not that important. Visa is only important when you travel outside of the country. On the other hand, status is your status here in America. It is very important when you stay in America. So without a visa, but with a valid status, you can definitely stay in America. There's no problem. But if you go outside of the country without a valid visa, you cannot come back. Airport official will not let you come back without a valid visa and a valid status. So what I advise, in this scenario, if you go outside of America for any purpose, that can be your home country or any other country, you have to apply for a visa stamping in a local US embassy. And sometimes it takes long time just to get an appointment. So what I tell my clients, let's say you are from India, you are in America, your visa expired, but you are in a good status. You need to go to India for some reason, family reason or something. First, apply for visa renewal in your local US embassy, get a date, and then you go to India and do your family things, and then get visa stamp from embassy, and then come back. So plan ahead so that you are not in trouble in the airport.
Okay. Also, can I hire an H4 visa holder for a temporary job while wanting for their EAD?
No. So sometimes some company, what they do, they will give you a conditional employment offer, like, hey, I'm offering you this job, but you can only start when you have your EAD card in your hand, because in the actual employment, like especially when they're going to run payroll, when they're going to give you salary, they must provide information about your work authorization. Without work authorization, they cannot pay you salary. So technically, like some companies, sometimes they do it, but it's kind of very I would not advise to do that. I would advise for even the company, and especially under this kind of situation, current president, he's very hawkish towards immigration. So I would highly encourage folks to wait until you get the EAD card in your hand, then you start working.
Thank you so much. Okay, so now coming questions are for the E2 visas, and the first question is, the business I invested in is struggling and I need to reduce my investment. Can I do this without jeopardizing my E2 visa?
Well, yeah. So, it's a very tricky question. I have to see the numbers, because to qualify for E2 visa, you have to invest in a certain area, a certain amount. And if you significantly reduce your investment, then I have to see whether after reducing the investment, whether it still is a viable business or not. So to be qualified for E2, you must have a viable business and you must run it properly. So if it is not a viable business, then you may lose your E2 status. But let's say you initially invested $100,000 and now you're reducing like a 10% and 20%. Let's say you reduce 20%. Now it's still a $80,000 investment. And with $80,000, it's still a viable business. Then you're good to go. No problem with that. But let's say you invested $100,000 and you're reducing to 80% reduction. Like now you have like a 20% investment, which is $20,000. And if it's not a viable business with $20,000, then you may lose your E2 status.
Thank you so much. There is a viewer over here who is asking a question, but it's in some other language. So, Mr. Mahajan, would you please like to answer that question?
Yeah, it's in Bengali language. So let me read it.
Yes.
It's আসসালামু আলাইকুম, এখন কি কোনো আমেরিকান কোনো সিটিজেনশিপ ছেলে যদি বাংলাদেশে এসে বিয়ে করে তাহলে তার বউকে কি অ্যাপ্লাই করে নিয়ে যেতে পারবে? So he is asking question, if a US she is asking question, if a US citizen man goes to Bangladesh and get married to a lady in Bangladesh, can he apply for her? Can the U.S. citizen spouse apply for his foreign citizen spouse? The answer is yes. They can always do that. They could do that before. They can do that now, and even down the line. Because so this is the thing. Any U.S. citizen, if they want to get married and they live with their spouse, is their constitutional right. Constitutional rights are very protected right. In very few situation, like an uncommon situation, US government can reduce that right. Otherwise it's protected by the constitution. So I do not see within any foreseeable time that any president will be able to cancel that right. On the other hand, when a permanent resident, they marry a foreign person and they want to bring the foreign spouse back to America, it's not their constitutional right. It's their privilege. So privileges are way weaker than constitutional rights. So that's why any US citizen marries a foreign person, it's way more protected and way more stronger case than a permanent resident, because again, it's a privilege, it's not a right. But the short answer to her question, yes, he can do that.
Thank you so much. There is one more question from the viewer. Can my LLC established for my O-1A visa practice in another state other than where the LLC is registered?
A short answer question, yes. It is very common here in America. Let's say you have a LLC registered in Delaware. Delaware is a state, and many people they register their business in Delaware. Like a 30, 40 years ago, that would make sense because Delaware is a very liberal state for businesses. But nowadays, most other states they also follow kind of Delaware rule. But yeah, short answer to your question, yes, your business can be registered in one state, and your principal place of business can be in other state. You can live in a totally different state. All three can work together. There's no problem. However, there must be a legitimate business, legitimate employer-employee relationship, and you must meet 3 of the 8 criteria.
Thank you so much. Now moving on to the E2 questions, E2 visa questions. My E2 visa is set to expire, but my business has not yet achieved the projected milestone. Can I extend my visa?
You can apply for extension. Whether your extension will be approved or not, that's a question. If your business did not achieve the expected milestone, most likely they will not extend your visa, but you can definitely apply.
Okay, so next coming question is for H1B RFE. And what if the requested document in the RFE are not available?
Well, that's a very bad situation. If they ask for something and if you do not have that, it's bad. But sometimes it may happen. So what I do in this situation, I write an explanation letter. I say, hey, you asked for this document, but I do not have this. And I tried my best with all the good faith effort. I tried my best, but I could not do that. So let me give you an example. So let's say you're from a country where there's a war going on at this moment, and nothing is working at this moment, and they are asking for a original authentic birth certificate. To get the birth certificate, you have to reach out the government of that country, but there is no functioning government because of the war. So you can write a explanation for this condition and also attach some evidence, like some news article from renowned source that, hey, there's a war going on, there is no functioning government, I cannot get the document, I'm sorry for that, but that's this is the situation. You can write a explanation letter, send it to them. Most likely they will accept it, but it's not guaranteed.
Okay, next question is my H1B lottery petition received on RFE. If it get denied, can I participate in next year's lottery?
Yes, no problem with that.
Yes. So I think that's it for today's question.
Thank you very much, Manashi, and thank you for all of our audience. I think we have some news article. Going back to Manashi.
Yes. Yes. So yeah, that's a wrap for the Q&A session. Mr. Mahajan, thank you so much for your time, your knowledge, and your ongoing comments to helping people navigate the US immigration system with confidence and care. And to wonderful audience, thank you so much for joining us today. If you are someone with exceptional talent and are exploring ways to work in US, we hope this episode gave you clarity and confidence about O-1. Immigration for All goes live every Monday at 11 a.m. EST, 9 p.m. Bangladeshi time, 7 p.m. GST, and 8:45 p.m. Nepali Standard Time. So make sure to subscribe, follow, and mark your calendars. That's all for today's episodes, and always stay tuned for a few immigration news updates right after this outro. Until next time, take care, and we will see you next week on Immigration for All.
Welcome to the latest episode of Weekly Immigration News by Raju Law, where we bring you the most important developments from the world of US immigration. Let's take a look at this week's top headlines. Green Card Wet List changes in August 2025 bulletin. Immigration support grows despite Trump's actions. USCIS announces new fees for immigration forms. Carnegie honors 2025 great immigrants. We begin with updates from the U.S. State Department on green card wait times. The U.S. State Department has released the August 2025 visa bulletin, showing the latest green card wait times. Most family-based categories remained unchanged, but the F2A category advanced by 1 month for all countries, while the F4 sibling category moved ahead by 3 months and 3 weeks for China and all other areas. In the employment-based categories, EB2 dates slipped by 1 month and 2 weeks. EB3 for India moves forward 1 month, and EB5 saw major progress for India and China. Next, a major poll reveals shifting public sentiment on immigration despite ongoing policy changes. A new Gallup poll shows that 79% of Americans now see immigration as a good thing, marking the highest level of support in 25 years. Support has grown across political groups as well, including Republicans and Independents. The number of Republicans who wants less immigration has dropped from 88% to 48%. Most Americans now support giving undocumented immigrants a chance to become citizens. These findings challenge Trump's tough deportation agenda. Now, an important announcement from USCIS that will affect application fees for many immigration benefits. USCIS has announced new fees for certain immigration benefit requests effective July 22, 2025, based on the HR1 law. The changes include a $50 fee for asylum applications and a $600 fee for employment-based petitions. These fees cannot be waived or reduced. Forms postmarked after August 21 without the required payment will be rejected. In more uplifting news, the Carnegie Corporation celebrates immigrants who have made remarkable contributions to American society. The Carnegie Corporation of New York has released its 2025 Great Immigrants, Great Americans list, recognizing 20 immigrants for their outstanding contributions to the United States. This year's honorees include public health advocate Sandra Leiza Lindsay, business leader Michelle Kang, tech entrepreneur Top Aotona, Nobel Prize winner Maunji Bawendi, and composer Tanya Leon. The list highlights achievements across fields like science, health, business, and the arts. Thanks for watching Weekly Immigration News. Stay informed and see you next time.